This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about what happens when an insured contends that her insurance agent lied to her about the terms and conditions of a policy, and finds out that an insurance agent has no obligation to investigate an insured's need for coverage, and why before filing a lawsuit or even making a claim, you must read and understand your insurance policy. Plaintiff Liza Sims' mother owned a house in Magalia, California, that was insured under a policy issued to her by Farmers Insurance. Before the wildfire called the Camp Fire, Sims lived alone in her mother's house and operated a cosmetic tattoo business there. After the house was destroyed by a wildfire in 2018, the insurance company paid Sims' mother the limits available under her policy, but denied Sims' claim for the loss of her personal and business property. Sims sued Farmers Group and insurance agent Dawn Foster for negligent misrepresentation and professional negligence. In the case entitled Liza Sims versus Farmers Group, Inc., the California Court of Appeals on January 24, 2025, attempted to get coverage for the destruction of her business property from a homeowners policy that excluded such coverage. The trial court ruled in favor of the defendants, stating that Sims' claims were legally insufficient because she could not show harm from the agent's alleged misrepresentations and could not prove that the defendants owed or breached any duty to her. Sims appealed, arguing that the court erred, and the appellate court, after reviewing all of the records, affirmed the trial court's decision. Sims' claims as an issue were based on the alleged misrepresentations by Foster about the insurance coverage on the property. The trial court concluded that Sims could not establish causation because Foster's alleged misrepresentations pertained to a different insurance policy that was no longer in effect at the time of the Camp Fire. Sims' evidence was insufficient to create a triable issue of material fact. The trial court also ruled that Sims could not establish Foster owed or breached a duty of care to Sims because the duties of an insurance agent run only to the client, and Sims was not Foster's client. Her mother was. The appellate court agreed with the trial court's findings and affirmed the judgment. Analyzing the issues, the court noted that negligent misrepresentation is a species of the tort of deceit. To prove negligent misrepresentation, a plaintiff must show 1. A misrepresentation of a past or existing material fact, 2. Made without reasonable ground for believing it to be true, 3. With intent to induce another's reliance on the fact misrepresented, 4. Justifiable reliance on the misrepresentation by the party to whom it was directed, and 5. Resulting damages. Sims alleged that she had 2 in-person conversations with Foster, the agent, in 2013 and 2014, where she was led to believe her business property was covered. The trial court concluded that Sims could not establish the elements of causation, justifiable reliance, and resulting damage because Foster's alleged misrepresentations pertained to coverage under an earlier homeowners insurance policy, which was replaced by the landlord policy in effect at the time of the fire more than a year before the Camp Fire damaged the house. The judgment was therefore affirmed, and the defendants were awarded their costs on appeal. The trial court ruled in favor of the defendants because Sims' claims were legally insufficient, and because Sims could not show harm from the agent's alleged misrepresentations, and could not prove that defendants owed or breached any duty of care. In her deposition testimony and discovery responses, Sims admitted facts that directly contradicted the statements in her declaration in opposition to the motion for summary judgment. Not a wise thing to do. Ordinarily, an insurance agent assumes only those duties normally found in an agency relationship. This includes the obligation to use reasonable care, diligence, and judgment in procuring the insurance requested by an insured. However, an insurance agent generally does not have a duty to investigate a customer's coverage needs, to procure coverage to meet those needs, or to point out the advantages of additional or different insurance covers. The trial court properly ruled that because the underlying claims against Foster failed as a matter of law, there could be no case against farmers, and the judgment was affirmed. In my opinion, insurance agents who do not take on the position of a fiduciary are basically order takers and are only obligated to obtain the insurance ordered. The fact that the agent may have told the plaintiff that her business property was covered by one policy, whether true or not, was not a misrepresentation about a subsequent policy totally different from the one in effect at the time of the fire. People really must read the policy before buying and clearly before making a claim or filing suit. The court did read the policy, and the plaintiff lost. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog and subscribes. If you subscribe, you'll receive notice of every blog posting, usually 5 or 6 a week, and you will gain access to the more than 4,950 blog postings. You can also subscribe to the videos. They are also free. And please tell your friends and colleagues about the blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing to my Substack publication. It's either a low price or you can get most of it for free. Thank you for your attention.